An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman.
The enforcement powers of the 13th and 14th Amendments, Strauder versus West Virginia, 1880, and the Civil Rights Cases, 1883. The 13th, 14th, and 15th Amendments emancipated the slaves and guaranteed the freedmen constitutional freedoms, including the right to vote. However, states began to enact so-called black codes that denied the freedmen their freedoms. In addition, terrorist groups like the Ku Klux Klan resisted Reconstruction. They killed the freedmen in lynchings and even gruesome massacres like the Colfax Massacre we studied in U.S. v. Cruikshank. In response, Congress enacted a series of enforcement acts. These laws empower the federal judiciary and the executive branch to protect the civil rights of the freedmen. For example, in 1875, Congress enacted a law that allowed criminal defendants to remove a case from state court to federal court if the prosecution results in the deprivation of the, quote, equal civil rights of citizens of the United States. Through this law, Congress explained that the state courts could not be trusted to protect the rights of the freedmen. Study Guide. What enumerated power gave Congress the authority to enact this law? The Supreme Court would consider the constitutionality of this removal provision in Strauder versus West Virginia. Taylor Strauder was accused of murdering his wife. Both were African Americans. At the time, West Virginia law limited jury service to white males. As a result, Strauder argued that his case should be removed to federal court because he was denied rights to which he was entitled under the Constitution. However, the trial court and the West Virginia Supreme Court found no reason, quote, why a jury of white men would not be quite as likely to do justice to the prisoner as a jury of Negroes. Moreover, that court found that the 14th Amendment was not, quote, intended to protect the citizens of any state against unjust legislation by their own state. On appeal, the Supreme Court of the United States reversed by a 7-2 vote. Justice Strong's majority opinion had two parts. First, the court found that the 14th Amendment's guarantee of equal protection of the laws protects the defendant's, quote, right to a trial by a jury selected and impaneled without discrimination against his race or color. Study Guide. Did the court invalidate the West Virginia law because it violated the 14th Amendment's Equal Protection Clause? Second, because Strauder's rights under Section 1 of the 14th Amendment were violated, Congress had the power to remedy the violation under Section 5 of the 14th Amendment. That is, Congress had the power to enact appropriate legislation to enforce the equal protection of the laws. Therefore, the case should have been removed to federal court. As a result, Strauder's conviction was vacated. Justice Field dissented. He found that limiting the jury pool to white men would not deprive the defendant of the equal protection of the laws. Therefore, quote, there is no warrant for the act of Congress under which the indictment in this case was found. Strauder was a rare case where the court upheld an exercise of Congress's enforcement powers under the 14th Amendment. The next case would take a very different direction. In 1875, Congress also enacted the most significant enforcement act, the Civil Rights Act of 1875. The law provided, quote, that all persons within the jurisdiction of the United States shall be entitled to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, subject only to the conditions and limitations established by law and applicable alike to citizens of every race and color, regardless of any previous condition of servitude. What happened if a business subject to the act excluded a patron on the basis of race? The United States could prosecute the owner for a federal crime. In addition, the excluded patron could sue the business owner for damages in federal court. Study Guide. What enumerated powers gave Congress the power to enact the Civil Rights Act of 1875. During the congressional debates, members of the House and Senate divided on this very question. Did the federal government have the authority to criminalize segregation in certain private businesses? Yet no one in Congress suggested that its power to regulate interstate commerce could support the Civil Rights Act. Rather, proponents of the Civil Rights Act cited the enforcement powers of Section 2 of the 13th Amendment and Section 5 of the 14th Amendment. The former gave Congress the power to enact appropriate legislation to eradicate slavery. The latter gave Congress the power to enact appropriate legislation to enforce the guarantees of Section 1 of the 14th Amendment. Ultimately, the Civil Rights Act passed a divided Congress, and President Grant signed it into law. Several years after Strauder was decided, federal prosecutors indicted the owners of segregated businesses across the country. Some of the cases involved, quote, denying to persons of color the accommodations and privileges of an inn or hotel. And contrary to common misperceptions, segregation was not limited to the southern states. For example, McGuire's Theater in San Francisco, quote, refused a colored person a seat in the dress circle. And the Grand Opera House in New York denied, quote, another person whose color is not stated the full enjoyment of the accommodations. In each prosecution, the business owner raised the same defense. The indictments were unconstitutional because Congress lacked the power to enact the Civil Rights Act of 1875. Each of these appeals was consolidated in a case known fittingly as the Civil Rights Cases. 8 years after it was enacted, 8 justices voted to invalidate the Civil Rights Act of 1875. Justice John Marshall Harlan was the lone dissenter. First, Justice Bradley's majority opinion found that the 14th Amendment's enforcement powers could not be used to regulate private businesses. Justice Bradley explained that, quote, civil rights, such as are guaranteed by the Constitution against state aggression, cannot be impaired by the wrongful acts of individuals unsupported by state authority in the shape of laws, customs, or judicial or executive proceedings. Justice Bradley added that the 14th Amendment was only intended to remedy the, quote, abrogation and denial of rights for which the states alone were or could be responsible. This, he wrote, quote, was the great seminal and fundamental wrong which was intended to be remedied. Justice Bradley also observed that the plain text of the 14th Amendment supported his position. The Privileges or Immunities Clause, the Due Process Clause, and Equal Protection Clause, he wrote, only restricted state action. This principle became known as the State Action Doctrine. Therefore, Congress lacked the authority under Section 5 of the 14th Amendment to remedy private civil rights violations. Study Guide. Is Justice Bradley's textualist argument persuasive? The text of the Privileges or Immunities Clause concerns the making and enforcing of laws, which can only be enacted by the government. This provision, therefore, seems to require state action. Similarly, the Due Process Clause's reference to the due process of law is limited to the state mechanisms for how laws are applied. Here, too, there must be state action. So far, so good. But the text of the Equal Protection Clause does not impose limitations on the enactment of legislation. Rather, equal protection of the law requires equal enforcement of the law. This language does not only protect rights from state action, it also protects rights against state inaction. The states now had an affirmative duty to enforce the rights of all people, white and black, male and female. That is, the government had to act to protect them from both governmental and private deprivations of their constitutional rights, including the privileges or immunities of citizens of the United States. This right of protection mirrored the Civil Rights Act of 1866, which mandated that all citizens were entitled to the, quote, full and equal benefit of all laws and proceedings for the security of persons and property. Study Guide. Is state inaction, that is, the failure to provide some with protection, a violation of the Equal Protection Clause? In addition, Section 5 of the 14th Amendment was added to enable Congress to enforce all the rights in Section 1, including the Equal Protection Clause. Therefore, under this reading of Section 1, Congress would have the power to enact laws that protect citizens against a state's failure to protect them from private actors who deprive them of their privileges or immunities when states have failed to do so. Several members of the Senate thought these privileges or immunities included fundamental natural rights to the, quote, enjoyment of life and liberty with the means of acquiring and possessing property and pursuing and obtaining happiness and safety. But this understanding was too radical for the Supreme Court to adopt in 1883, and so it remains today. From that day to the present, the Supreme Court has applied the state action doctrine to all three clauses of Section 1. In his dissenting opinion, Justice John Marshall Harlan did not deny the textualist claim that the 14th Amendment is limited to state action. Instead, he contended that discrimination by the inns, hotels, and theaters in fact constituted state action. Specifically, under the common law, so-called common carriers were obligated to accept all paying customers from the general public. Public conveyances such as railroads, as well as inns and hotels, were considered monopolies. They could only turn away customers who were willing and able to pay for good cause. Justice Harlan admitted that so-called public amusements were not traditionally viewed as common carriers, but the theaters required a public license to operate. Therefore, the governments who granted such licenses were bound to ensure that all of its citizens had access to these public spaces. Study Guide. Are you persuaded by Justice Harlan's finding that discrimination by the inns, hotels, and theaters constitutes state action? Are some of his rationales more persuasive than others? Unlike the 14th Amendment, the text of the 13th Amendment was not limited to state action. Rather, it prohibited slavery even when perpetrated by private individuals. As a result, the court had to resolve whether the types of discrimination barred by the Civil Rights Act constituted slavery. Or more precisely, the question was whether such discrimination amounted to the reinstitution of slavery. If it did, then Congress could prohibit such discrimination pursuant to Section 2 of the 13th Amendment. The majority and dissent agreed, in the abstract at least, about the appropriate tests concerning the enforcement of the 13th Amendment. In addition to barring slavery itself, Congress could also enact laws that were necessary and proper to abolish all badges and incidents of slavery. Study Guide. What are the badges and incidents of slavery? The majority inquired whether, quote, the denial to any person of admission to the accommodations and privileges of an inn, a public conveyance, or a theater subjects that person to any form of servitude or tends to fasten upon him any badge of slavery. The majority concluded that it did not. Justice Bradley observed that applying the Civil Rights Act, quote, to every act of discrimination would be running the slavery argument into the ground. He concluded that, quote, mere discriminations on account of race or color were not regarded as badges of slavery. Study Guide. Is the prior existence of African slavery in the United States relevant when considering whether disparate treatments of African Americans constitute a badge or incident of slavery? In dissent, Justice Harlan contended that the segregation in hotels, inns, and theaters were badges of slavery. Therefore, Congress could prohibit those badges. Since slavery, quote, rested wholly upon the inferiority as a race of those held in bondage, Justice Harlan observed, quote, their freedom necessarily involved immunity from and protection against all discrimination against them because of their race in respect of such civil rights as belong to freemen of other races. Among these civil rights was the right to access common carriers, such as inns and other places of public accommodation. In conclusion, the majority and the dissent had very different conceptions of how the federal government could combat the aftermath of state-sanctioned slavery. Justice Bradley contended that the government had already done enough for African Americans. Quote, "When a man has emerged from slavery, and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation when he takes on the rank of a mere citizen and ceases to be the special favorite of the laws, and when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected." Justice Harlan vigorously disagreed. Quote, "The one underlying purpose of congressional legislation has been to enable the black race to take the rank of mere citizen. The difficulty has been to compel a recognition of the legal right of the black race to take the rank of citizens and to secure the enjoyment of privileges belonging under the law to them as a component part of the people for whose welfare and happiness government is ordained." But alas, Justice Harlan was the lone dissenter. To this day, the civil rights cases remain good law. We previously studied how Slaughterhouse, Bradwell, and Cruikshank contracted the scope of the Privileges or Immunities Clause. In a similar fashion, the civil rights cases contracted the scope of Congress's Section 5 powers. However, the Supreme Court would, over time, compensate. First, the court would compensate for the loss of the Privileges or Immunities Clause by expanding the scope of the Due Process and Equal Protection Clauses. And second, the court would compensate for the loss of Congress's enforcement powers under Section 5 by relying on an expanded reading of Congress's other enumerated powers. Specifically, the Supreme Court upheld the landmark Civil Rights Act of 1964 as an exercise of Congress's powers under the Commerce and Necessary and Proper clauses. But the Supreme Court had not yet reached the low point of its protection of civil rights. In our next case, Plessy v. Ferguson in 1896, it would further weaken the 14th Amendment's due process and equal protection clauses.